Tim's not coming.
Good afternoon, everyone, and welcome to the Delaware Public Service Commission meeting of September 8th, 2016. A internet shout out to Lori Lee.
It's September 6th.
September 6th? September 6th. It's this week. An internet shout out to Lori Lee Murphy with thanks for all the help for the Delaware Commission, and especially myself as I prepare for something I've got to do this month. So that's appreciated to Lori Lee Murphy. And also be kind to me today because my grandson is in the room in the back there checking things out. And the first thing on the agenda, which I've hidden for myself, is the meeting minutes. Anybody have any corrections or changes to the minutes?
Move we adopt the minutes of August 23rd as presented.
I seconded.
Is there any discussion on the motion to approve the minutes? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? And we have one member traveling today and not present. So, the next thing on the agenda is the consent agenda. There's one item on the consent agenda. Assuming that there's nothing that needs to be changed or pulled from the agenda. Commissioner Gray.
Yes, Mr. Chair, thank you very much. I have a couple of questions related to this item, and so I don't know whether you want to leave it here or we should take it off and put it on the regular.
Okay. The consent item is now placed at the end of the regular agenda. And on the regular agenda is the first is the matter of the petition of Direct Energy Services requesting that we issue on an expedited basis an order directing Delmarva Power and Light Company to distribute an educational bill insert regarding the options available under the contract awarded by the state of Delaware to Direct Energy. And is there anyone here from Direct Energy that wishes to present this matter?
Mr. Chairman, if I may, this agenda item is only to consider petitions for leave to intervene. We've had one filed. That is from the Retail Energy Supply Association, and I believe Mr. Green is here. And are you Ms. Kielsen?
No, I'm not. I'm Ms. Latimus.
Latimus. Okay. I don't think you folks are needed at this stage unless you have a position on the petition for leave to intervene.
No, we didn't. We just wanted to make sure we understood what was happening today.
Okay. Right now, what's before the commission is RISA's petition for leave to intervene. And I will defer to council if you'd like to present his client's petition. That's Mr. Green.
Mr. Green was present and is present. Mr. Green, why don't you come forward? You come all the way from the great Commonwealth of Virginia, so we'd like to hear from you.
And his admission pro hoc is pending in this matter and will be before the commission on the 20th because we did not receive it in time to put it on today's agenda.
I'm Brian Green for the Retail Energy Supply Association. We filed a timely petition to intervene, and there's a pending pro hoc motion as well. I don't think there's any opposition to RISA's intervention here. I think that the council to my left and right might have a different matter they might want to discuss, but I don't think it involves the petition to intervene.
Well, we're addressing the petition to intervene and nothing else at this time, so they probably won't have anything to say. Ms. Mayorek?
The commissioners are well aware of the commission's rules and regs as pertain to interveners. There would have to be, it's on the petitioner to show an interest in the outcome and why that interest would not be represented by other parties or why their participation would be in the public interest. And it's up to the commission to decide whether the Retail Energy Supply Association has met those standards in its petition. Staff takes no position.
Mr. Goodman.
We have no objection to RISA in this, Your Honor.
None here either.
Ms. Iori?
No objection.
Any questions from the commissioners of any of the parties or the interveners or motioners or whoever's present here right now?
Mr. Chair, I move that the commission approve the RISA petition for intervention in this matter.
Second the motion?
Is there any discussion on the motion to approve the intervention? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? And we have one not voting. Thank you all very much.
Thank you.
May I ask a quick question, Your Honor?
Is it on the agenda?
No, it couldn't be on the agenda, but we have an emergency issue that's come up, and that's the problem. All the parties are here for it, and it's the reason it's going to need to be addressed is we have a commission consideration of something that is on the agenda and has been scheduled for a while for your next meeting on September 20th. Right. But what happened was Wednesday evening, the petitioner took it upon themselves to file expert testimony. And as you can imagine, that kind of blows things apart. I've never seen anyone file expert testimony, essentially 2 weeks before the commission is going to consider something. So what you have before you is a motion to allow additional time because Delmarva and joined by public advocate, neither of us considered that it was going to be an evidentiary hearing. There was no schedule for it. You just said you were going to consider the petition. So we feel more than a little bit surprised here. And so we filed an emergency motion requesting some guidance since we have this coming up on the 20th. If you think it's best to discuss it when the regular agenda is over, I just think it really does need to be addressed.
Ms. Iori?
We do share Delmarva's concern. We filed a supporting document in which we actually flipped the relief that Delmarva's seeking. Delmarva had sought to either extend the schedule to allow for discovery and then have an evidentiary hearing, or the way that the DPA read the Commission's opening order in this and the way that these matters have been handled since I can remember. When the Commission has asked for comments, generally it's the people who are commenting on it are not the same people who filed the petition in the first place. And then when the Commission has a hearing, it is generally simply oral argument. If that, in fact, is what the Commission intended with this order, then striking the pre-filed testimony and simply hearing oral argument on the petition and the comments filed in response to it, we think would take care of the issue. If, however, the Commission is going to have an evidentiary hearing at which it will hear testimony from parties, then we agree with Delmarva that the schedule needs to be amended to reflect time for discovery and to submit our own pre-filed testimony.
Is there anyone else who wishes to make comment? Ms. Mayrack, are you? Is this yours?
Mr. Chairman, Commissioners, representing staff in this matter, it's staff's position that because Delmarva's motion was not printed on today's agenda, which Commission regulations would require be printed on an agenda in an emergency situation at least 6 hours before the meeting, which would have been 7 a.m. this morning, that it would be a violation of FOIA, the Freedom of Information Act, for the Commission to consider it today, and that these issues can, whether or not to strike something or consider something, can certainly be taken up before the hearing on the 20th. That said, staff is absolutely agnostic to whatever procedural schedule the Commission puts in place in this docket, but would suggest that just given how it's proceeding so far, that some clear guidance for all the parties would definitely be in order and might eliminate future disputes.
And as the Commission's counsel, I am advising you that I agree that it's under FOIA. I don't believe we can consider this motion today. You could consider it at the beginning of the meeting on the 20th, depending on how you resolve this motion. I don't know what happens to the rest of the hearing that day. It depends on how you resolve that. Or you can set up some kind of a structure today to say that all the parties should have all their comments in response to this by the 13th so that you guys can consider that by the 20th. I'm just not sure how the commission wants to handle that. And whether the commission intended the 20th to be an evidentiary hearing or only oral argument. People can read the order different ways, I suppose, and only the commissioners know whether you really intended evidentiary hearing or oral argument on the 20th.
Well, just,
Commissioners, I'm Tara Latimus. I'm here on behalf of Direct Energy. So if I could just address some of the comments.
in what capacity are you here on behalf of Direct Energy?
I'm their counsel.
Okay.
So I'd just like to address a few of the issues that were raised by the other parties. If Your Honor, if the commission were to take a look at the public notice that was filed in the paper, you'll see that in connection with filing motions to intervene, it says if you wish to formally participate as a party in this matter with the right to present evidence at the September 20th, 2016 hearing. So clearly, we read this as being an evidentiary hearing. And while I understand that this may not be what we filed, may not be, it's probably unique, but I haven't heard anyone say that it was procedurally inappropriate. And I think if I understand Mr. Goodman's position, somehow knowing about the testimony today is somehow more prejudicial than knowing about it on September 20th. So I don't really understand what that reasoning either is. And then with respect to discovery, we've actually reached out to the parties in this case to discuss a procedures order where we can engage in discovery. And I think Mr. Goodman had a discussion with my colleague last week about doing that, and that suggestion was rejected. So we have tried to move this process along. We've received resistance. And so we would like to proceed with the hearing on the 20th. We have, in our response that we filed to the motion this morning, we have suggested that the parties would have the right to file reply briefs and testimony and whatever else that they want to do, as long as we also have the ability to do that. Because we think that the more information that the commission has, the better. But we also think that we need to move forward on the 20th so that the consumers can have this information as soon as possible. Thank you.
So I haven't presented my motion. I just heard argument against that. All I did is tell you why it needs to be considered today. Since we just heard the argument against my motion, maybe you could let me present it so you know what we're talking about, because you haven't even gotten the introduction as to what's going on.
Again, we're getting into a whole argument now that was not on our agenda.
No, I understand.
And I don't know that we should do that.
I understand.
And the problem with that is it said that you could make a determination on this before the 20th. You don't meet until the 20th. And the problem is, and if you could let me, I can present this as to the problem can't be corrected by hearing it on the 20th, and then depending on whatever the decision is, we may be having a hearing. That's the core of the problem. It's the Administrative Procedures Act and the Due Process Clause. So, I think now you're in a situation where you don't know what the motion is, and you're trying to make a decision, having heard arguments against it.
I don't think we're trying to make a decision because it's not on the agenda. It's in violation of the FOIA, and I don't think that we have the right to make a decision on that today. So, and it's an emergency, but it doesn't seem to really be an emergency per se. So I think that what we're going to do is we're going to see you on the 20th of September, and we'll see how you all, as parties in this matter, either work out something together, or we'll have to make a decision once it's on the agenda, and we can discuss it on the 20th of September. I don't see any way around it.
I understand, but I have to point out that this was caused by what we consider to be a very serious violation, and you're not intending to do this, but they're being rewarded for it, and that's what's most upsetting.
Violation of what, Mr. Goodman?
Well, I have never before seen anyone do this, and I know they wouldn't try it in court, but I don't think it's appropriate to spring expert testimony on someone at the end, the last potential filing date for something. They sprung an expert report. I don't believe that's civil. I know it's not permitted by the order. This commission has never permitted that. I've never seen anyone bold enough to try it. That's what's happened. So when you said interested parties shall file comments to the petition, That's what you said. That's the order for the parties. You don't all of a sudden, when you are the petitioner, having presented your fully developed argument, then come forward with written comments to your own petition and say, by the way, surprise everyone, here's a nice expert report. Deal with this in 2 weeks. That's what happens. So now we don't know what is going on 2 weeks from today. We don't know how to prepare for it. We can't do discovery. We can't go out and get our own expert. That's the problem. We've been put in this very bad situation, not by you, not by anyone here, but the client of Ms. Lanimus. That is our problem. We don't know what to do. It's a terrible violation of due process and your rules and your order.
If I could ask that Mr. Goodman identify specifically what rules and regulations we violated, because again, what I've heard is our procedure is unusual, but we looked at the rules, we tried to do this the best way and in the way that was required by the rules. It was not clear. So there was references in the rules to verifications, which is how we filed this testimony. And again, Mr. Goodman seems to be arguing that knowing about an expert on last week is somehow prejudicial to knowing about it on the day of the hearing. I just don't understand that. But notwithstanding that, we are more than willing to work with the parties to get together a process where everyone can get the discovery that they need, everyone can file their comments that they want. We're willing to cooperate fully. We just would like to move forward on the 20th so we can get this information out to consumers.
Well, you both agree. You say it's unusual, and of course, Mr. Goodman uses different language to say the same thing, which is something he hasn't seen, something I haven't seen, and I expected that there was going to be an oral argument and a hearing on the 20th of September, and so we're going to proceed, and it's going to stay on the 20th of September, and the emergency motion will be noticed for that day, so we'll be in compliance with FOIA, and this commission will make a decision on the 20th of September, and the parties will, I'm sure, talk and try to mitigate whatever problems exist in this docket. And we'll get on with it on September 20th. Okay, next item on the agenda is in the matter of Verizon Delaware LLC's USAC e-file certification of their FCC Form 480. Number 2, like I said, number 2, I apologize. In the matter of the application of Delmarva Power and Light Company for the approval of the 216 program for the procurement of solar and renewable energy credits.
Mr. Chairman, actually, this is staff written order. If Ms. Scott doesn't mind, I'll take the lead. Commissioners, you have before you proposed order number 8890 in docket number 15-1472. This is the full findings, opinion, and order from an evidentiary hearing that was held before the Commission on May 3rd of this year. The Commission did adopt a minute order that approved Delmarva's solar renewable energy credit application for 2016 at the May 3rd meeting. This order that you have before you today simply incorporates the testimony that was heard at that hearing, as well as the Commission's deliberations and direction in this docket. This form of order was circulated to the parties. There was some feedback, although I'm not sure that I can represent right now that the parties are in agreement with this form of order. I'll let them speak to that. There was one typo corrected that should be in the version you have before you today. It is in paragraph 21, really just added a word that had been inadvertently omitted. So staff urges the Commission to adopt order number 8890.
Thank you very much, Ms. Mayrack. Ms. Scott?
Thank you, Chair Winslow and Commissioners. As Ms. Mayrack indicated, she did prepare a form of order that was circulated to the parties for comment. For the most part, the order is acceptable to Delmarva, although I'm proposing an amendment to ordering paragraph number 1. And if I could approach, I have red lines to show what I'm proposing to change.
Does Ms. Mayrack have that already?
She is aware of the issue. I provided this to her previously. The proposed change to ordering paragraph number 1, which appears on page 15 of the decision, is to add language that has been in every order in this particular matter since the SREC program went into effect. And essentially what it does is it includes language that in approving the program, the Commission makes a determination that the program complies with the provisions of RESPA and is in the public interest. Again, that is language that has been in every order since the inception of the program. It's clear, at least to me, from the provisions of Title 26, Section 353 of the Delaware Code, that there is a need for the Commission to find that, in fact, in approving this program, it is in compliance with the provisions of the Renewable Energy Portfolio Standards.
Thank you, Ms. Scott. Ms. Mayrack?
Staff, upon further review and consultation, does not oppose that change.
Are there any other changes, Ms. Scott?
That is the only change, Your Honor.
Ms. Iori?
Public advocate takes no position.
Commissioners, any questions of Ms. Scott, Ms. Iori, and Ms. Mayrack? Would someone like to make a motion on this findings, opinion, and order?
We adopt order number which has been revised and presented to us in last 1 minute with the revision.
With the Delmarva's suggested change.
Yeah,
added to
the
it.
one they suggested. Yes.
Just a point of order for your motion. Is this not order number 8890 in the agenda?
It is.
Yes.
The
Should we call
language
it?
is not on that page, but it is.
Call it for the record. So a revision, perhaps the order 8890 as edited?
Yeah, we can, yeah. So move. Yeah.
I second.
Is there any discussion on the motion as presented by Commissioner Correa? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? Motion passes 4-0. Thank you very much, Ms. Scott, Ms. Mayrack, and Ms. Iori. The next item on the calendar is the Verizon matter that I mentioned earlier, with all of the different numbers, which don't mean anything to anybody probably. And Ms. Metz is not here representing Verizon, but I believe that Ms. Mayrack, is this yours as well?
This is Dag Willard's.
No.
Oh, it is. Mr. Willard?
Yeah, Verizon is not here, is that right?
Correct.
Yeah, this is a letter that Mr. Howitt was urged to prepare and has prepared. I'm sure he can respond to any questions you might have. You have the letter in front of you, and we would just request that you okay this letter.
Any questions of Mr. Willard or staff?
Move that we accept the, and direct Mr. Howard to send the draft letter to the FCC as presented.
Second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The motion passes 4-0. Number 4 on the calendar is in the matter of the adoption of rules and regulations relating to the creation of a competitive market for retail electric supply service. You'll see regulation docket number 49. Welcome, Mr. Green. I'd like to start this docket off, please.
Sure, I'll kick it off. Brian Green for the Retail Energy Supply Association. On or about August 15th, 2016, RESA, along with DPA, filed a joint motion and submission for the Commission's consideration today. This involves the current status of the electric supplier rules that we've been working on for quite a long time now, and the question today really is whether a new version of the rules needs to be published prior to considering them, and then second, if that's the case, what do you publish? And let me explain. The rules have been published on at least 3 occasions for comment in the last 4 years. And I say at least 3 years because there were also at least one time where staff sent out a new red line to the parties for comment, but it didn't get published. So the parties, and specifically RISA and DPA, as the 2 primary parties in this case, have expended numerous resources and filed an unbelievable amount of comments and red lines and suggestions on what the rules ought to look like over the last 4 years. The most recent publication was in January of 2016. The parties again filed comments, and shortly thereafter, the Commission opened case 15- in that time frame, I should say, the Commission opened case 15-1693 to consider other choice enhancement programs, and one of the 7 or 8 items that the Commission directed the parties to do is finish the electric supplier rules to help develop the competitive market for residential and small commercial customers. So with the status of 49 being what it was, which was floundering, and with the Commission's direction in the other case, RISA and DPA began a series of meetings where we could try to see if we could come to an agreement on most and even maybe all of the contested issues, and there were quite a few. This resulted in some pretty lengthy meetings, some pretty lengthy phone calls. DPA's consultant was involved. RISA's members, who are active in virtually every market where choice is allowed, were able to bring that experience to these negotiations. We looked at Maryland specifically, that just adopted new rules. We looked at Pennsylvania, which just adopted new rules, and has implemented most of those. So we had a lot of expertise and experience to lean on, actual experience in the marketplace to lean on. And what we came up with was a 100% consensus document between RISA and DPA. Now, when we filed our motion on August 15th, there was still one issue left open. We were able to resolve that issue last week. So we have copies of the RISA DPA electric supplier rules, that version, for the Commission's consideration. Our view is that because these are really comments on what was published in January of 2016, that the rules don't need to be republished for comment, that the Commission can consider this version and adopt them. But in the event that there is going to be a republication, if the Commission goes in that direction, we think these are the rules that need to be published for comment and not the version that staff has proposed in its proposed order to you today. And it's not just because we all put a lot of time into this. And just to finish the chronology, bless you, staff. So we submitted our version, the DPA RISA version, to staff and to Delmarva for their proposed comments. And time went by, and we ended up receiving from staff an extremely extensive set of red lines, which was unexpected. So, and not only were they extensive, but they really cut on quite a few of the issues where either DPA had compromised or RISA had compromised in order to get either something else or to make something better. And what I mean by that is, if Pennsylvania had a rule that we liked for consumer protection purposes, we wanted to try to bring that to Delaware, but maybe it didn't fit perfectly the way it was written, so we tweaked the language to make it, to tailor it to Delaware. Or maybe something has it been in place in Pennsylvania for a couple of years now, but we've noticed, our members have noticed that it's a little vague, that it needed to be refined. So we tweaked that language so as not to have that or those issues in Delaware to clean it up. So what we came out with, we feel, with the primary two parties in the case, a very appropriate balance between consumer protections on one hand and developing the competitive market for residential and small commercial customers on the other. What staff has done with our version, though, is they've redlined it so extensively that it disrupts that balance. And in Reese's view, actually tilts it against the market. Happy to get into why. But there's really no need for the extensive changes that staff is proposing. Like I said, it disrupts this balance. We feel DPA is happy with it. Reese is happy with it. It addresses a lot of the same issues, the staff redlines, but just in different ways, which we considered. But for whatever reason in the art of compromise, we didn't go in that direction. So, again, the consumer advocate is happy with it. The retail suppliers who we want to come to Delaware, those that are in Delaware, we want to expand our offerings. We want this to work. And staff's version is going to do two things. It's going to delay the process because it's going to call for another publication. And that you may or may not care about that. But the bigger issue is that it's not the balance that we need in Delaware to create competitive markets. It's going to cause, I've canvassed our members, and we've dealt with some of these issues in other states, it is going to cause suppliers to stay away from Delaware. And for certain suppliers that are already in Delaware, it's likely to cause them to reconsider. Those are how big some of these issues are that staff is demanding, which we have put in writing time and again, are market killers. Throughout this process, we have told them that, and for some reason they continue to show up in staff's version, even though we've kind of gotten beyond a lot of that with DPA. So I'm happy to go into specific details. I think from a high level, I'm happy to talk about the added consumer protections that the recent DPA version brings to Delaware citizens, while at the same time allowing for competitive markets and giving suppliers additional information so they can find customers, and then once they find them, they can serve them more easily. I'm happy to get into all of that. There are additional protections, upfront disclosures so that customers better understand what they are considering, the product that's right for them before they enroll, before they sign the contract, and then also during the course of the contract. If it's a variable contract, for example, which caused so many concerns during the polar vortex time period, there are additional disclosures throughout so that customers know what their next month's price is going to be, and they have time to avoid it through accelerated switching, where they can switch faster in 3 business days rather than what could take up to approximately 45 days. There are additional upfront disclosures for marketing materials. If you quote a price, you've got to give your 12-month historical information with the disclaimer, obviously, that historical pricing is not indicative of future pricing, but this is going on in Pennsylvania right now. This is working in Pennsylvania, where if you quote a price, you got to give your historical information so customers can see, okay, they've got a variable price. Well, what has their variable price been for the last 12 months? So it's that kind of thing that gives greater upfront disclosures and greater disclosures throughout the course of the contract. There's also additional consumer protections for door-to-door sales, additional protections for telemarketing sales. There's clarity around the rescission period for customers. It brings it in line with what is in place right now with Pennsylvania, with Maryland's Door-to-Door Sales Act. Maryland, in the electricity arena, does not have a rescission period, but it's 3 business days, and where the clarity really comes in, it's when does it start? It starts depending on the enrollment method, but it starts when the customer enters into the contract, which is transparent and makes sense. Customers can easily understand that, and suppliers can easily figure out when does that period start for customers. The 3 business day switching is incredibly important. Staff has it in their version as well. It's written a little differently. We just track the language from Maryland, because if Delmarva's affiliate is already doing this in Maryland, we thought that's the easiest way to get there here in Delaware. We know it's going to take time for Delmarva to implement 3 business day switching, so we just took the same language and said, well, that, hopefully that will help expedite things. There's information or provisions in our version that deal with suppliers' ability to access customer-related information. In Maryland, for example, and we brought this concept into Delaware, with customer consent, a supplier can access pre-enrollment information, it's called. So if you're at a mall and you go to a kiosk with a supplier, you're not going to know your account number, and you're certainly not going to know your 22-digit service number that's required for enrollment. So you can get that information with the supplier can get that information with customer consent to be able to better serve or better to more easily enroll the customer, but then also information on historical usage and so forth to be able to better tailor products for that customer. There's also a provision that's currently in place in Pennsylvania on customer lists, where customers opt out of a customer list process. This has been in place now in Pennsylvania for, I think, about 3 years. There have been, to our knowledge, no concerns, no major mistakes or significant privacy concerns in the last 3 years. But EDCs, the distribution companies in Pennsylvania, turn over a significant amount of information to the suppliers, and there's all kinds of security or limitations on what the supplier can do with the information, but it helps the suppliers find customers. It opens the door for marketing, and the proposal that we have in our RISA DPA version is that Delmarva would update the list monthly, so for people that move or that whatever, go on service, go off service, that list is continually updated, and then every year Delmarva sends a notice out saying we're going back to ground zero now, and you can opt back out for the next year. That's an example. It's a little bit. Pennsylvania's every 3 years. Here, DPA and RISA, as part of our compromise, thought 1 year was appropriate. But those are the kinds of things that. So the balance that we've created between DPA and RISA of customer protections, ensuring that customers know more at all times. And I just hit on some very high-level points. There's a whole lot more in our document. And also that it gives suppliers certainty that they can come to Delaware, they can get information, they can serve customers easily, and offer the types of products that they are offering in numerous other states. So I've talked for a long time, happy to answer any questions. But we would ask today that the version that we just passed around, which is the 100% consensus agreement between DPA and RISA, which did not come easy, that be approved today, and that there is no need for another publication for comment. We've done that 3 times already. This case has been going on for more than 4 years, and we feel like it's time to bring it to a close.
Thank you, Mr. Green. Ms. Iori?
I don't have much to add to what Mr. Green said. I just do want to tell the Commission that the document that you have in front of you was very hard fought. The DPA did not get everything it wanted, but RISA members didn't get everything they wanted either. We believe that after 4 years without basically what are fairly bare bones regulations under which electric suppliers have been operating that don't have the kind of customer protections that the DPA thinks is very important, these proposed rules have sufficient customer protections that the DPA was willing to propose these to the Commission for its adoption.
Your advice on the publication issue?
We share RISA's position on the publication issue. That the Commission published regulations in January. These are essentially a response to that, and that the Commission can decide today. If, however, the Commission believes that those rules need to be republished, that we would ask that the DPA and RISA's proposed rules be republished for comment, and that the Commission hold a hearing on October 18th. And with respect to that, although Mr. Green did not get into this, it's probably a little down the road, but if that in fact is what happened, then the other part of our motion comes in, which is to postpone the current evidentiary hearing
Thank you, Ms. Elroy. Mr. Goodman?
Thank you, Chairman. So, we understand the issue here is to be whether or not the rules need to be republished due to the changes, and we don't have a position on that. I just wanted to come up here to just, I know you want the facts, and I know that Mr. Green operates in so many jurisdictions that it's probably a little hard to keep it straight. So absolutely not blaming him because he knows more about this stuff than probably any of us will. But one thing that was said is with respect to 3-day switching, it said that they are doing 3-day switching now in Maryland. I just wanted to make sure you understood that they've agreed to do it, and it's taking about a year and a half to actually get it in the system, program it through the system, and that's what's occurring now. So I thought that'd be important for you to know.
I thought that's what Mr. Green said, but maybe I'm wrong.
The 3-day switching in Maryland is in the regulation that was just approved and became effective in approximately March, April, May of 2016 time period. Each of the utilities sought a waiver because the requirement was that I don't remember what the requirement was, but they all sought waivers and needed more implementation time. And the commission directed that the utilities, including Delmarva and Pepco, implement 3-day switching by December 30th, 2016. In the most recent status report in July, I believe that Pepco and Delmarva stated that they could be 90% of the way there, which is really the most important part. I don't need to get into the other 10%. I think if we get that 90% in, that is going to cover absolutely most of the switching involved. So Pepco and Delmarva had initially sought a waiver. I believe they were the ones that sought until August of 2017, and the commission said no. And BGE had sought until March of 2017, and the commission said no, we're all going to do this by December 30th, 2016. So that's where we are. It's not in place yet, but they are putting it in place, and they're well on their way to have 90% of it in place by the end of the calendar year.
Like I said, I agree.
Mr. Geddes?
Mr. Chairman, members of the commission, let me tell you what I think this is about, or not about first, and then what I think it is about. First of all, substance. Forget the substance. It's about process. And unfortunately, we try diligently to bring matters before you that I think are ripe for determination, and that there is a real choice between option A and option B. In this case, I don't think we've achieved that for you, and I apologize on behalf of staff. But if you look at the motion, and I know this is Ms. Iori's work, but the background is very, very good. Yes, this case has been going on for 4 years, but there have been a lot of twists and turns, and it is complicated. But the first question for you to answer is, should we republish these rules, or should we not republish these rules? They suggest you don't need to. I suggest that their own papers indicate a contrary conclusion. And that's where on page 4 they state, the proposed rules completely overhaul the current rules, and as such, it was not possible to redline the changes over staff's proposed revisions January. Now, query, if you cannot redline a document, I think it's a natural conclusion that they are substantially different. And I contend that RISA and DPA's work product is substantially different than the January 2016 draft. So I think that answers whether you have to republish or not. I think you have to republish something. So the second question is, what are you going to republish? Now, there have been a lot of twists and turns, and it is true that RISA and DPA went off their own volition and spent from March until July hammering out a version of these regulations. Nobody else participated in that. Staff did not participate. Delmarva did not participate. I would suggest to you that staff and Delmarva are stakeholders in this process. This is what they chose to do. They then sent us their proposed regulations in July, and staff diligently has been working for 2 months rather than 4 months to consider some of those proposed changes and reject some of those proposed changes. So what you have before you are two different documents. One, neither of which has had all stakeholders sitting around a table trying to argue and to provide you with a red line copy of some version, whether it's RISA's or whether it's staff. That is not in front of you. So for the commission, you have two different types of regulations. Now, there probably is another choice, and that is to direct the parties to do a procedural development that the motion does not bring before you. But what we tried to do, staff, is to create an order, to publish regulations, and to provide a time period when we can sit down, hopefully with them, and either work it out, but based on Mr. Green's comments, perhaps we cannot, but at least have something before you on the 18th where you can say, okay, I agree with this position, I disagree with that one, and basically have a conference, if you will, similar to the legislative process, where you bring the two sides together and you work out some kind of agreement. And if it has to be done in front of the commission, well, so be it. But I don't think it's fair to say, well, because RISA and the DPA believe that their rules and regulations are better than staff's, that theirs should be published. We have been working with staff's versions and comments to staff's drafts of these regulations, and the compression of the choice docket, which is really what's driving this. Originally, RISA did not believe Reg 49 was associated with that. Now they've come to the conclusion we need rules and regulations for suppliers before that choice docket can go forward. That's always been DPA's position, but RISA's come around to the DPA's position. So it's staff's order that is before you that would publish staff's versions of these regulations after having reviewed what the DPA and RISA did. The other choice is to publish RISA and DPA's, but again, Delmarva and staff were not part of that. So we recommend our order to you. We're sorry that we've put you in this position, or at least personally, I'm sorry I put you in this position. And hopefully by the 18th, we can come and before you, if that's your desire, and give you a red line copy if we can't agree, and you'll have to go through it, regulation by regulation. Thank you.
Thank you, Mr. Geddes.
Very brief comment.
You go first.
Go ahead.
Yeah, I just want to make a brief comment. Delmarva does have some comments that it thinks it does, need to make about a very few things, but there are some things in the rules. So, Mr. Geddes did bring up that it wasn't brought in front of all the parties, and so I just think in fairness, there are some things that we would like to discuss that we think needs a tweak or two. But at the same time, I congratulate DPA for trying to move it forward and doing it in a way that really does protect customers. They've done nothing wrong. I think they've done everything right as far as trying to work something out, and we appreciate that greatly. But we do have a couple comments, and that might be helpful for you, having heard what Mr. Geddes said.
Mr. Green?
So in response to staff's comments, every version that has been published, every comment that has been filed, practically in this case, certainly by RISA and DPA, would overhaul the current rules. Because the current rules, as Ms. Iori said, was very scant. They don't say a whole lot, and they were begging for more details. So the idea that just because our version overhauls, I think you can look back at any of the proposed regulations that were published, the three or so that were, as well as staff's others that they sent out, as well as RISA's red lines, as well as DPA's red lines. They were all overhauls. And RISA, I know we filed either 2 or 3 sets of comments, each ranging from 37 to 58 pages of red lines and explanations of why the red line was necessary. DPA, the same thing. So the other thing that was somehow just implied was that the DPA-RISA meetings were somehow top secret, that no one knew we were out there doing it. We not only talked to everybody about it and told them we were going to do it, but we gave them updates as to how we were proceeding, not substantive updates, but we've gotten this far, or we think in a couple weeks we'll have something for you guys to look at. We invited staff to do a walkthrough when we sent the version to them. I'm happy to get on the phone with you and walk through this with you, and so we can show you what the changes were and what our reasoning was for these changes. We didn't get a response to that. So, what Mr. Geddes said about bringing the two sides together, I mean, the two most diametrically opposed parties in this proceeding are DPA and RISA. So we've already done that. The party that is statutorily responsible for protecting residential customers and the parties that are needed to create a competitive market have sat down and worked it out. And if anything is going to be published, we feel like it's not necessary, but if anything's going to be published, it should be the DPA RISA version that is the product of a lot of hard work, a lot of resources, and quite frankly, it's a document that I'm really proud of, and I think that it draws from so many other jurisdictions. It draws from the DPA's consultant, from our members who have seen and done quite a bit throughout the choice-related or choice states. It is, by my account, a very appropriate balancing of interests. There's nothing, I don't think Mr. Geddes was implying this, but there was nothing unsavory or nefarious about what DPA and RISA did. I just want to be clear on that. We went and we worked it out, because if you look back at the docket, you look at the comments, the ones that were the most opposed to each other, really, were RISA and DPA. And so for us to be able to sit down and work it out and still maintain a very high level of consumer protection, not only much more than we have now in Delaware, but much more than are in other states. And I'll give you one example. In the RISA DPA version, for telemarketing calls, other states require that you record either the sales portion of the call or you have a TPV, right? In our version, you have to do both. Okay, so a TPV, after someone calls you at home, and you go through the whole sales portion and you agree, yes, I want that product. I want to be your customer. The supplier or the merchant, the seller, has to third-party verify. And and you may have gone through this. They say, okay, thank you very much. We have all your information. I'm going to transfer you to someone who's going to verify that you really do want to do this. And so there's a verification process where you get transferred to, usually it's a third party that's contracted by the supplier to say, are you John Smith? Is this your address? Is this your account number? Do you understand that you're switching suppliers? Do you have authority to make the switch? Or whatever the questions are. We've actually got set questions in our version of what the TPV person has to ask the customer. Do you understand that your rate is this? Do you understand that it's a whatever type contract, fixed or variable? There's a whole set of questions. So it's just one example of how the RISA DPA version goes beyond what's in other states.
Would you please address what Mr. Geddes said about the document you filed and the wording he referred to that and argues that it needs to be published because of your own language in the motion?
Well, every version that we've seen has been an overhaul. I mean, the 3 published versions already that everybody commented on, and the comments themselves would overhaul not only the existing rules, but the published, proposed revised set. So we're not going to get one here where I can guarantee you that if you publish the RISA DPA version and then you see the staff red lines that we've seen on top of our version, it's going to be another overhaul, right? Because what they're proposing to do would overhaul the RISA DPA version. So we're not going to get there without an overhaul. So the point that we are trying to make in the motion was that we've put in an incredible amount of work here to come to a very appropriate solution. And we feel like it can be heard today, it can be adopted today, but if you're going to publish, then publish ours.
Commissioner Gray.
Thank you, Mr. Chair. So on this matter, as I read through some of the documents provided prior to the hearing, I have to compliment RISA and the DPA. I think you did a fairly good job from what I saw in the contents. I feel as though we're on a journey to the same destination, but we've kind of reached a fork in the road, and you're asking us to choose which lane we're going to take. The fact is, from my perspective, the journey is not sufficiently complete for us to make that choice. And it sounds like some of the stakeholders that need to be involved in the process to reconcile the differences have not really been in the same room to do that. And it's a little uncomfortable for me to look at even the style and the layout of the two documents, because it doesn't appear that I can make a one-to-one comparison about the content that are contained in each. So I'm confused from the standpoint of being asked which document to publish, if it needs to be published, and how complete is it. So, Mr. Chair, I'm just not convinced that the stakeholders have yet brought this process to the point where we have a reconciled document that they have weighed in on and told us that this is what we recommend for the marketing component of the company, as well as the customer protections that are necessary to move this forward.
Well, Commissioner Gray, I would concur with your comments, except for the fact that I think this docket has been open for a substantial part of my entire term on this commission. You know, I'm frankly not willing to vote or support anything that's going to delay the implementation for our consumers and our businesses in the retail market any longer, so we can accommodate people who have not participated with DPA and RISA, notwithstanding the fact that they knew that those negotiations were ongoing. And so I'm very adamant that this matter has got to get off the table and it's got to get done. Frankly, it's a little. We can't point to this whole situation as being the best effort of this entire commission. It's just been a very, very rocky road, and I think at some point in time you got to put down your foot and say that's the end of it, and that's where I am, and that's what I'm going to support.
Was there a particular reason for not inviting the staff and Delmarva to the meetings or series of meetings, even though this may be the platinum version of the customer benefits or customer protection, like verification and what have you? Was there a particular reason why they were not invited or asked to attend, like sending a letter and say, here is a meeting, please come, coffee is free?
We felt like we felt like the two diametrically opposed parties were DPA and RISA. That if you looked at the prior comments that were filed in the docket, there were some big ticket items that DPA and RISA, if we couldn't resolve, we needed to be able to see if we could somehow compromise or how firm we were in our respective positions. So we began these meetings, and I can give you examples of what these big ticket items are, but I don't know if that helps move the ball forward in your eyes or not. But we felt like that because this had been published 3 times already, and then other red lines had been sent out by staff, that it was time for DPA and RISA to be a little stronger in this docket and help bring this matter to a close so that we could see what issues can we narrow and take them off the table, and then be able to present the commission if there's not a consensus on everything. Maybe we've narrowed it down to 5 or 7 items, but the rest of it's done. But then the more we discussed and talked, we got to 100%. So, and that was the initial goal, was let's try to narrow the items for the commission and for the other parties. And we got a lot farther than we had thought we were, quite frankly, going to be able to get. But the idea was that we'd get as far as we could and then send it out to everyone. And that was always the objective from the beginning. And everyone knew that.
Commissioner Correa, may I offer a comment? I don't think Delmarva was not opposed to the idea that DPA and RISA wanted to work on these rules together. But I think from at least our perspective, we thought that we would have an opportunity to then respond to the final version before they were presented to the commission to be approved. We have provided them with our comments about some questions and concerns we have, but we have not had the opportunity to have any further dialogue about how to address those. And so, again, we had no problem. We knew that they were off talking about this and trying to work through their issues, but we always anticipated having the opportunity when they came back with what they were going to present to then sit down and work and go over the issues with them. And we have not had that opportunity as of yet.
May I be heard briefly? Thank you, Chairman. So that is true. We have gotten comments from Delmarva, and we also got staff's red line. With respect to the commission determining which version, because I think what I'm hearing is that you think some version needs to be published, and it's just a question of which one. As to which version should be published, we should suggest it should be ours, and then the 30-day time period under the APA runs. Delmarva files comments, staff files comments. We see what we can work out. We have a hearing on the 18th, and if we can't reach agreement on it, then it's before the commission to decide. But at least it's going forward. I mean, as long as we have this, we have drafts going back and forth. There's never a deadline. There's never a date where that's holding all of our feet to the fire, and that has been the problem. And that's why this thing has gone on for 4 years.
Very briefly, these are the commission's rules, and so the commission should be, cognizant of that. Staff's version is the only version that has actually looked at RISA and the DPA's version and tried to incorporate some of those changes. I can tell you personally, with regard to green power, we had a conference call with Mr. Green. Staff proposed some changes. He at least initially thought that they were, valid concerns. We sent those comments to him. So staff has reviewed, and those comments are in this draft of staff. So staff's is the most mature draft. Now, they haven't had a chance to comment on our comments, but if you want to publish something, staff's order says that the draft of these regulations, which has been reviewed by a staff member and commented on, which is attached to the order, is before you, and it creates the time frame that, Mr. Chairman, you're concerned about. We would suggest, respectfully, that staff's regs be published and that the timeline apply, as Ms. Arroyo stated, except that RISA and the DPA will be filing the comments, not staff. And we'll have it before you on the 18th with a red line that will go through line by line where we have disagreements.
Mr. Geddes, we have basically a settlement agreement between RISA and DPA. And you're going to turn that settlement agreement on its face, so to speak, and have us redline staff's document. And I understand the logic for your argument, and it makes sense. But it just seems to me like, given what's happened in this process, that we'd be better off redlining RISA and DPAs with staff comments, where you, first of all, hopefully it'll be resolved if we go through this a little while longer, and staff has a chance to sit down with RISA and DPA and discuss why they come to certain compromises. It might make some sense to staff, and staff might then concede, or perhaps not have as much in terms of redlining to do. That's just, I'm just thinking out loud. It might be less less work at the end of the day if we start off from where the settlement parties are sitting right now.
Well, that obviously is up to the commission as to whether you think that that's the most appropriate way forward. We respectfully think that staff's version should be published, but obviously you have another version that has been, as you said, reached agreement between two of the four central parties to this. Plus, there are other parties as well who may want to comment. RISA, represents some suppliers, but I don't think they represent them all. So there'll probably be other interested parties that may provide comments as well.
Just on that note, I would be remiss if I do have authority today to say that Commerce Energy and Direct Energy, that are both active in the market in Delaware, support the RISA DPA version and the relief being requested by RISA, just for the record.
Commissioners, any further questions? Commissioner Conaway?
Just to get this over today and maybe off to a better end, I would like to make I would like to make a motion that we publish RISA DPA's rules for certification and regulation, and that they come back before us on the 18th of October, right? To get this thing settled once and for all. Please.
Is there a second?
Yes, I second.
Is there any discussion on the motion to publish RISA and DPA's settlement agreement language and schedule this matter for hearing on October the 18th? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? Motion passes 4-0. My thanks to everyone. No, 1 second.
Part 2 to this.
Mr. Green?
Here's the second part to our joint motion, which is impacts the procedural schedule in case.
We should have made that part of the other motion, I think. That's the issue with respect to the other document or docket, the number of which escapes me right now, but that would probably be more appropriately rescheduled to after October 18th. That's the request, right?
Yes.
Right.
If we could basically postpone the proceedings of that until the commission has made a decision on the 18th, because that way we will know what is still at issue in 1693 that we still need to argue about, because many of the issues in that docket are overlapping with the draft rules.
Commissioner Conaway, would you agree to a
Yes.
change in the language of the motion to include and incorporate that?
Yes, I would.
Are there any objections? Any of the commissioners that voted in favor of the motion?
That would be fine.
Okay, all three commissioners agreed that was okay. Mr. Rowan, should we vote again? Or are we okay?
No, I think you should vote again, to be clear.
Okay. Mr. Conaway?
Before you're voting, just point of clarification. Under our order, comments had to be filed by the 1st of October. I assume that you want to keep that as part of this overall motion.
Yes, sir. Thank you very much.
Is the number on that docket 15-1694?
93.
93.
And just to clarify, we're postponing that evidentiary hearing indefinitely or to a date certain?
Indefinitely. It's on the table. It's a request of PPA and RISA.
All right, then you've got to postpone action on docket number 15-1693 until the former matter is settled, correct?
Correct.
Second.
Is there any discussion on that motion? Hearing none, all in favor signify by saying, and also the October 1st date is incorporated in that, Commissioner Conway? Did I miss that?
Yes.
All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion passes 4-0. My thanks to everyone for the discussion. There's nothing on our hearing schedule today. I see that Mr. Noyes is here from
Mr. Chairman,
Point of order.
number one on the consent agenda was,
Yeah.
Delayed.
We delayed
consent
number
agenda.
one.
that's still for us.
I was trying to get Mr. Noyes before he got out of the room. Okay, the consent agenda item
Call catchers.
Mr. Bowman here and Ms. Mayrack, or is it Mr. Willard?
It's Mr. Willard, yes.
You want to present that, please, sir?
Yes, this is the order regarding the matter of the application of Call Catchers, Inc., doing business as Freedom Voice Systems for a certificate of public convenience and necessity to provide intrastate long-distance telecommunications services within the state of Delaware. The staff has reviewed this in great detail and prepared a staff memorandum recommending that this permission be granted and proposed an order here before you today, which would allow this to take place. I believe staff is probably here to respond to any questions you might have, and we would urge you to adopt this order.
Commissioner Gray?
Yes, thank you very much, Mr. Chair. Okay, I'm a little confused here in that when I read through some of the requests of the commission, the applicant respectfully requests the commission consider Freedom Voice proposed ownership as it considers this registration, or to the extent required, approves the acquisition by GoDaddy Operating. I didn't see anything in the staff information that addressed the acquisition, merger, or the change in ownership. I didn't see a good standing certificate, and I didn't see a consent to jurisdiction or any profiles of the new management. So I'm just curious, is there anything that the commission should be concerned about that this portfolio is changing ownership as we make this decision?
I do not believe the commission has anything to be concerned about. Again, I don't have the specific information you're looking for. I don't know if... Oh, okay, there you go. Staff is right here, and can you respond?
In regards to your question...
Identify yourself for the record,
Okay.
Josh.
All right. Josh Bowman, staff analyst assigned to this docket. The question Commissioner Gray asked about the transfer of control, that was brought up to the company when they first filed, and they were notified that in order to proceed, they would have to decide whether they wanted to proceed with the CPCN first or the transfer of control. They couldn't go through with the transfer of control without getting a CPCN first. So we gave them the option of either. Hold on, let me.
I guess while you're looking, I guess my question is, if you're going through the transfer of control, is the CPCN going to new management?
CPCN is going to, what they were told was the CPCN would go to call catchers doing business as Freedom Voice, and then they would have to file a 215 with us for approval of the transfer of control to the GoDaddy company.
Okay, so that comes back again through the commission.
Yes.
Okay.
That'll be at a later time.
Two other quick questions. There was a indication of an attachment D, a good standing certificate, which was not in my package, and have they consented to Delaware jurisdiction?
The attachment D that I have with, do you have this stuff?
No, I don't have it. I didn't have any D sections in my attachments. That's why I was raising the question.
Did you have any of them, if I may ask?
Yeah.
Okay.
I had licenses and things of that sort, but I had no good standing.
Okay. Well,
Did any other commissioner get an attachment D?
We have one here.
Yeah.
oh, okay. Well, if you want to see it.
Is there
You have one? Yeah.
This is what was included as the attachment D with what I got.
Is that a good standing from the business secretary?
I, Jeffrey W. Bullock, Secretary of State, do hereby certify Call Catchers, Inc. is duly incorporated under the laws of the state of Delaware and is in good standing and has a legal corporate existence as far as the records of this office show.
Excellent.
As of the 23rd day of June, 2016.
Okay, and the only other question is, I didn't see a consent to Delaware jurisdiction.
They have to consent to be. cases have to be heard in Delaware.
Most of the other addresses are out of state, so I'm just curious.
They do have a registered agent in Delaware. Is that?
I mean, the registered agent in Delaware seems to imply that you're going to be in Delaware's jurisdiction. That's why you have a registered agent.
Thank you very much. Chair, I have no further questions, and I'll make a motion that the commission adopt proposed order number 8936 as submitted.
I'll second the motion.
Is there any discussion on the motion to approve the proposed order? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The motion passes 4-0.
Thank you for your assistance.
Thank you, Mr. Willard, Mr. Bowman, Commissioner Gray. I think is there anyone here from the public that wishes to make comment to the Public Service Commission? Mr. Noyes.
Thank you, Chair Winslow. I have a couple of informational items to bring to your attention. The Delaware Renewable Energy Task Force will be meeting tomorrow morning in this hearing room at 9:30, and we will be discussing the results of the most recent SREC auction and starting to consider the next SREC auction. And so your order that you adopted today will be very timely in that. The Division of Energy and Climate will be holding 2 workshops on the Green Energy Fund for Delaware Power grants for solar energy. As market conditions change and costs change for solar energy, the division has a number of times since the inception of the program changed the incentive levels. And we will be having a workshop on this Friday, September 9th, in the DENREC conference room on 391 Lucas Drive, and Monday evening, September 12th at 6 p.m., again in this hearing room, and we do appreciate the use of your hearing room, to brief the public on considerations that we, on factors we take into consideration in reviewing the grant levels and soliciting comments from the public. This is to help get the wisdom of the public and the industry on what we should be thinking about as we consider changes to the Green Energy Fund. Thank you. That's all I have.
Thank you, Tom. Mr. Howitt.
Chairman Winslow, Commissioners, my first endeavor for Director's comments would be to ask Commissioner Conway if she would very graciously share a new proclamation by the Governor, Jack Markell, and if she would share that with the audience, I would be appreciative of that.
It's been a long meeting. I'll try to read quickly. This is a statement in observance of Imagine a Day Without Water, which will be celebrated on September the 15th, 2016. Whereas the infrastructure that brings water to and from homes and businesses is essential to the quality of life and economic vitality of the state of Delaware, and whereas the crisis in Flint, Michigan showed the severe impacts of what can happen to the health and well-being of a community without access to clean drinking water, and whereas changes in weather patterns are causing epic drought and widespread flooding in regions throughout the United States, putting pressure on water systems that are ill-equipped and ill-prepared to manage such extreme events, and whereas utilities nationwide are grappling with aging infrastructure and lack reliable revenue and funding to maintain systems, let alone upgrade their systems, and whereas 1/5 of the United States economy would grind to a halt without a reliable and clean source of water, and whereas managing water responsibly is critical to our nation's environmental health and to a high quality of life through economic commerce, power generation and recreation, and whereas innovation in water conservation and water reuse will drive job growth, economic development, and establish a 21st century paradigm of water management in the United States, and whereas green stormwater infrastructure will not only ease the burden on our sewers, but provide a maximum return in benefits to the public, the economy, and the environment, and whereas for every one job created in the water sector, another 3.68 jobs are added in the national economy, and for every $1 spent on infrastructure improvements, the United States generates $6 in returns, and whereas different regions face different water challenges, so the solutions to strengthen our drinking water and wastewater systems must be locally driven, but reinvestment in our water must be a national priority. Now, therefore, I, Jack A. Markell, Governor, do hereby declare September the 15th, 2016, Imagine a Day Without Water in the state of Delaware, to recognize that water is essential to quality of life and economic competitiveness, and acknowledge the importance of educating the public about the value of water through the Imagine a Day Without Water campaign. Signed, Jack Markell, Governor.
Thank you, Commissioner Conaway. Just to alert you, I've already made our staff aware that we will have no water supplies and the bathrooms will be shut down on September 15th. So I would advise you not to come to the commission offices on September. No, I'm just kidding. I do want to express my appreciation to Commissioner Conaway. She has been our water expert, our water guru in terms of everything that's gone on at the commission, at the national level and at the Mid-Atlantic, the MACROC level. And I certainly want to thank her for her efforts on behalf of trying to help us out and keep us straight on water infrastructure and quality of water. Appreciate your efforts on our behalf. Thank you, Commissioner Conaway.
You're very welcome.
Knowing that you want to shorten this meeting as much as possible, I've invited Mr. Farber to come talk to you about sorry, it's just the way it works out. I've invited Mr. Farber to come here and to talk to you a little bit about the Northeast Transmission Development Corporation's revenue requirements at FERC, and I know I will pass the baton to Mr. Farber for any good details that he can share with you.
Thank you, Mr. Howard. Mr. Chairman, Commissioners, good afternoon. With apologies for adding on to an already late meeting. This item is to address a proposed settlement agreement in a filing that was made before the Federal Energy Regulatory Commission, or FERC, in docket ER 16-453. This filing was made by Northeast Transmission Development, LLC. I'll refer to them as the company, or through various corporate organizations, LS Power. Essentially, this filing was to obtain approvals for the formula rate and protocols to recover costs associated with the Artificial Island project, which I think you're already aware of. In this filing, the company requested a base return on equity of 10.5%, as well as a 50-50 theoretical capital structure that would apply up until the project went in service. At that point, the equity structure would represent actuals. By order of the FERC on April 26th of 2016, the filing was accepted, and the matter that was set for hearing was solely the return on equity. The parties requested Judge Brenner to be our settlement judge, and he graciously accepted. And we had a number of settlement conferences supervised by Judge Brenner. We had conferences on June 21st and 22nd, June 27th, as well as July 19th. At that last settlement conference, Judge Brenner noted that the participant had reached an agreement in principle, and that is what is subject of our discussion today. given that this discussion would have to address confidential settlement negotiations, I would request an executive session in order to make my recommendations to the Commission.
Commissioner Conaway,
Move that we go into executive session.
is there any discussion on the motion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes 4-0.